Thank you so much. And now the session you've all been asking me for at least 15-20 लोगों ने मेरा जान खा लिया है यार तुम लोगों ने कि ये सेशन कब हो रहा है ये सेशन कब हो रहा है. We are going to talk about new criminal laws, hits and misses, and we have an avid list of panelists. These four speakers, and I think we are going to introduce them. Request all the speakers to be here. Geeta Luthra ji. Geeta Luthra ji started practicing law since 1980s. Ma'am, if you're here, please approach the dais. S Nappinai, who's a senior advocate. Shobha Gupta ji, who's also a senior advocate. And Kunal Vajani, who's also a joint managing partner at Fox and Mandal. Just recalling the names, Geeta Luthra ma'am, and S Nappinai sir, Shobha Gupta ma'am, and Kunal Vajani sir. If you're here, please join us on the dais. Thank you. Guys, a huge round of applause for all our speakers, please. We're just getting started with the introductions. Geeta Luthra ma'am started practicing law since 1980s. She's been handling matters related to arbitration, representing public sector undertakings, handling myriad phases of law, including criminal, constitutional, economic offences, money laundering, and human rights. She's the Vice President of the Indian Council of Arbitration. She's a member of the International Academy of Family Lawyers and Law Asia. It's a pleasure to have you on board, ma'am. S Nappinai sir is a senior advocate, a Supreme Court advocate at the founder. Oh, okay, yeah. Sorry, ma'am. S Nappinai ma'am is a Supreme Court advocate and the founder of Cyber Sathi. As a senior and renowned lawyer focusing on litigation and policy work, apart from her social responsibility engagements for training judges, police, armed forces, students, and industry. Ms. Nappinai is an advisor, Maharashtra Cyber Police and senior panel advocate, Central and Western Railways, Government of India. Shobha Gupta is a seasoned legal professional with 25 years of practice in the Rajasthan High Court, Jaipur Bench, and 23 years in the Supreme Court. She is the founder of Flag Free Legal Aid Group, providing free legal aid to juveniles, and We the Women of India, focusing on women rights. Thank you for joining us on the dais, ma'am. Finally, Kunal sir, I think is a joint managing partner, Fox and Mandal, and a leading dispute resolution practitioner. Kunal sir also holds the distinction of being the court member of Court Member India, ICC International Court of Arbitration, Paris, as well as the Standing Council of Municipal Corporation of Delhi. Armed with a law degree from Government Law College, Bombay, India, and masters from Harvard Law School, Boston, USA, Kunal sir is also qualified as a solicitor for the Supreme Court of England and Wales and a registered practitioner holding rights of audience before the DIFC courts, Dubai. The floor is open for you, sir. Thank you.
Thank you very much. And I think on behalf of the panel, I apologize since we were coordinating with each other and we got a little delayed. I think we're here this morning with a sense of festivity, and I think the day is quite exciting, exhilarating, because I'm sure each of you have thoroughly enjoyed the panel since morning. This afternoon picks up a very, very exciting topic, and my compliments to Oak Bridge Publishing to keep this topic in the afternoon, because you pick up a topic which people then don't fall asleep about. You pick up a topic which people are now worried what's coming in July. What is going to be the criminal law regime in July? We lived since 1860 in a colonial hangover of the Indian Penal Code. We reformed our procedural law in the year 1973. We had our own set of Evidence Act. But now we have completely overhauled this entire criminal jurisprudence into indigenous names, and all of them being Sahitas or Adhiniyams. what has happened? The question is, and for my stellar panel, fortunately, it's all women, and the leading women in the criminal jurisprudence. So I am honored to have this privilege of being able to moderate this panel with Mrs. Geeta Luthra, Ms. Nappinai, and with Ms. Shobha Gupta. All of them who I have seen from my younger days and grown with them as a senior colleague. Two of them are now designated, and Ms. Luthra has been designated for years together. So I'm sure this afternoon we will get a sense of advice, a sense of reality, and a sense of caution on how the criminal jurisprudence is going to pan out in the next decade. I'm not sure how many of you know what's happened with the Indian Penal Code. The colonial hangover is asked to exit. We now have called Bharatiya Nyaya Sanhita, which has in all 357 sections, 21 new offenses, and something which I advocated as a law student is have some punishments linked to community service. So 6 offenses are now put down for community service as punishment. 19 offenses from the colonial era have been deleted, and you now have a regime which recognizes what is called as petty offenses. Before we move to the next law, may I request Ms. Luthra to give her comments on her overview of whether this is an old wine in the new bottle, or are we really in a forthcoming era of new criminal jurisprudence, new sense of offenses, new way of dealing with these offenses, and a new regime of punishment. Ms. Luthra. No, volume.
There is one mic which was not working.
Okay. Hello.
Yes.
You're otherwise also loud enough. So.
She's not loud, she's heard.
The only part of the introduction and the follow was, which I don't agree with Kunal, is he said, I have been watching them from my younger days. He is in his younger days. So I don't know what he is talking about. This is Kunal Vajani, ever young. So this is the person that when we've had a party till 2 a.m., we can ask him, where's the after party? So this is the Kunal Vajani we are talking about. Thank you for being our moderator. So now about the criminal laws. Is it old wine in a new bottle? Is it, as Mr. Kapil Sibal has said, is it just a cut, copy, paste? I feel that if a person like Macaulay sat for years and end, days on end in drafting what was the Indian Penal Code, even though it was modeled on other codes, then we needed a extremely erudite, painstaking job, because see what are the 2 codes? The Civil Procedure Code, the Criminal Procedure Code, the Indian Penal Code, these Evidence Act. These are the very basis of common law. So we needed any change in the law to be extremely, extremely painstakingly, carefully done. And at least I was and I must say, maybe amiss, I was part of the committee that made suggestions. There were suggestions taken from the Standing Council's criminal. There were suggestions taken from the Police Council. There were suggestions taken from senior advocates. Even after the coming in the force of the bill, a lot of us were asked that even after the bill, do you have suggestions? But the suggestions are not enough. You need master draftsmen who, if you are actually making a new law, if you are actually rehashing the law, and if you are actually not rehashing the law and just tweaking certain sections, like you are increasing the power of the police to investigate, which has been done in this case, then you can do it as an amendment in this law. If you want to change the corruption laws, the Prevention of Corruption Act, you don't need to import it into the penal laws because it's a separate enactment. So, what's the purpose? Today, when the new law comes later, then the Parliament is presumed to know that there was an old act. The old act says that you have to go to the special courts. The new law will take you to the normal criminal court. Punishments have been increased. Now everything should have a rationale. I'll give an example because otherwise I'll be hogging all the 15, 20 minute or 1 hour we have for this conversation. So take the example of 304A of the Indian Penal Code. After the BMW case, where Suresh Nanda's son had been caught with the BMW, and although a case had been made that this was not a BMW, it was a truck, there was a witness, the witness then turned hostile, then turned whatever, he was, there is a whole, it's a movie by itself, it's story for a movie by itself. But the fact is, there were cases like that which came to light where young, yuppie kids driving BMWs and Mercedes after being drunk at night and mowing down people. And that's when they said 2 years is not enough. Rash and negligent driving should come for punishable with not being a non-bailable offense. And I've seen cases, any rash and negligent act, a fire in a place which breaks out accidentally but could be rash and negligent. There were cases like that which had come up. I recall several such cases. I don't want, because there's a right to be forgotten, so I don't want to name the entities. But those cases led to a thinking that the punishment should be increased. Wasn't it simple enough just by increasing the punishment? Why did we need to amend the law? If we needed to delete 19 offenses, why couldn't we delete the offenses? If we needed to bring in community service as a punishment, which I believe is very progressive, and which also came as a result of the Sanjeev Nanda case, where he was asked to do community service, and more the courts seem to suggest that in certain cases. Couldn't we have just brought in that amendment that apart from Probation of Offenders Act, we will have community service also? So wouldn't it be more pragmatic, easier to follow for the courts and lawyers, easier to follow precedents that have existed by not changing the sections? भाई हम हर आदमी ये बोलता है ये तो 420 है, because we know 420 stands for cheating, so we call it 420. Now if you give it another name, all of us will get confused also. Forget the accused, forget the police, lawyers who are doing this day in and day out will get confused. Why are you confusing us with changing the section? You are actually, in some senses, it's old wine in new bottle with new names, with new sections, with non-definitions. So we are really going to have people struggling. And several definitions are missing. One of the most scary aspects which was there in the bill, but which has been now sought to be redressed, is that 15-day remand, because there was seeming to be that there will be no end to the remand. Even though Supreme Court in that Senthil Balaji case had said 15-day remand means 15-day remand. It can't be more. And it is a scary power to give to the police. So while your police reforms have not come into being, which according to me had to be the precursor for bringing in any amendments which give the police more power, which take away the law of Lalita Kumari. So what did Lalita Kumari say? Lalita Kumari says that if there is a cognizable offense, you have to register an FIR. The only exceptions are, say, cases of commercial transactions where you may feel that this is a civil dispute, could be a criminal dispute, you would do a preliminary inquiry. The others are matrimonial offenses, because a lot of matrimonial offenses, even though being non-compoundable, end up in settlement at one stage or the other. So they introduced that there should be a preliminary inquiry. People will rope in chacha, dada, bhatija, everybody. So to try and not register the FIR against anyone, people who will be innocent also, there were these few provisions which have been said in Lalita Kumari, that in these you can have a preliminary inquiry. Now you're taking away that power and giving it to the police, and you're not carrying out police reforms. So apart from the fact that this is old wine in new bottle, slowly, invidiously, the power of the police, which should be reduced, because we are not a police state, the power of the police has actually been invidiously increased, both in cases of provisions of economic offenses. They are trying to take away, bring in a reverse burden for bail cases. So there are many such things. I think this is enough for the moment. Thank you so much.
Thank you, ma'am. Ms. Nappinai, I'll move to you. And this is a very different topic. Whilst Ms. Luthra gave us an overview of the entire forthcoming statute, I'll go to a specific provision. Sedition has now been replaced. And the section of sedition seems to have got larger words like endangering sovereignty, unity, integrity of India, and collecting of arms for rebellion against the government of India. There is a new definition of terrorism which has been introduced. So, like Ms. Luthra said, could these not have just come by way of amendments? Could these not just have been simplicity replaced? Why was this inane desire to forget 420? And what was the need for this overhaul? Second question to you would be, where do you see these provisions taking? Everybody today has somewhere or the other lived in the fear to see the abuse or misuse of these kind of provisions. So replacing sedition with any of these kind of provisions, do you still see that threat of misuse and abuse?
It's a difficult question. Let me see to what extent I can address it. So, good afternoon, everybody. So, one of the advantages that I had with the session being delayed is I got to hear the person who was speaking, I think, a couple of sessions before us. I felt that that was a perfect segue for our session. So, I'm going to step back from Kunal's query to answer one fundamental aspect, and to kind of tie into what Geeta was mentioning earlier. So the step back I'm doing is to ask you all this question. When the issue about bringing about criminal reforms happened, did you believe that criminal reforms were needed in India? I would think it would be a resounding yes, right? Of course we needed criminal reforms. That leads us to the next question of what kind of criminal reforms did we need? We needed substantive criminal reforms, not in the context of changing the sections, not in the context of just summing up and reproducing the provisions of the criminal major acts, not just in the context of introducing some new provisions which will capture some of the evolving criminal scenario, such as, apart from what you mentioned, Kunal, there is also this aspect of organized crime and petty organized crime which they have introduced. And if you look at it, you'll see that it is a capture-all. And that also captures some aspects of cyber crimes, right? I think there are a lot of people who are very interested in speaking. Please come onto the stage and speak if you wish. People in the back of the room, please feel free to come onto the stage and speak if you wish, right? So there are a lot of additions if you look at it. So the issue then brings us to, so the next question is, how could you have brought about the change? And that's where Geeta's input really come into play in terms of where could you have seen it. And one more comment, if I could add to what you mentioned, is one of the leading lawyers also called it a cosmetic change. So here is where my stand is. The first part of it, and in fact this was something that was very close to my heart, with 33 years of criminal law practice behind me and having seen the rot, if I may use that word, the rot that had set into the system, the ailments of the system, the kind of backlogs we have seen, the inability of the system to deal with this kind of backlog or with this kind of churning of cases day on day. And the way the system is merely surviving by moving the docket from one day to another. We are not seeing really justice being done. And if you look at every field of law, that field of law which needs justice to be done is the criminal justice system. Because that is impacting our life, our liberties, our rights, most importantly, fundamental rights. Be you on this side or that side of the fence, right? In 2013, when the criminal amendments were proposed, that was the first time they proposed the introduction of a definition for victim. And that was the first time they wanted to bring in provisions which will help victims, to give them certain rights. Because whenever you looked at a criminal justice system, it invariably was facing the accused. It was all about protecting the rights of the accused, lest there may be some abuse. And I would say rightly so. You definitely needed those protections because day in and day out we have seen the way the system is being abused. Therefore, on one hand, if you ask me, should we not have those rights at all for accused? I would say, of course not, you need it all completely. But we also needed a new jurisprudence to evolve, which was about victim rights. For whatever reason, they dropped certain parts of the victim-facing provisions in the 2013 amendments. They retained a few things which was almost salutary, like the right that they gave for you to appeal against an acquittal, for you to have some kind of a representation in the, where you could only assist prosecution. They kind of strengthened it a little bit, etc., which was still much diluted. So it brings me to the questions that have been posed to me and what my take is on the criminal major acts I'm going to cover all three together due to paucity of time, and I'll try to keep it very crisp. And I'll be only adding to what Geeta said. I'm not going to repeat any of those things. The first and foremost, we are practitioners for three decades plus. So if you ask us, are you happy with the sections being renumbered? Certainly not. We are we are not really interested in relearning our laws, right? So we would have obviously been happier with the original criminal major acts continuing and with just the modifications that were needed to be done. The way I looked at it, and I had also the privilege of presenting before the Criminal Reforms Committee, I also had the privilege of rendering my expertise to one of the ministries for their inputs on the three major acts, and this was what my position was then, this is my position now. Retain it as it is, give it a Bharatiya name if you want, that's up to you, but please don't lose track of the purpose, which is to reform the criminal justice system. So my first input is, do you think that these three criminal major acts have reformed the criminal justice system? Sadly, no. Have they at least brought in some improvement? Sadly, no. Could they have brought in some improvement? Definitely, yes. So let me jump from substantive provisions. I know you posed the question to me on substantive provisions, but I'm going to address the more critical issue here because the criminal justice system relies on the procedural aspects. We needed to have that strengthened, streamlined, and modified to suit current situations. The Evidence Act probably was at a time when they assumed that from the time a criminal is caught to the closure of trial, it may be a few days or a few months. So the Evidence Act, again, for a civil proceeding also, is expected to be for a limited period of time. But what you see today is years and years. And if you have taken the same old wine into the new bottle, and the new bottle is also not even modified, except to create the basic problems for all the old-timers here, then it is not going to reform the criminal justice system. And I'll tell you just one illustrative instance. I won't go into each of the sections. This is my pet peeve. How many of y'all have suffered because of section 65A and B of the Evidence Act? How many cases have come about which talk about whether we really needed special provisions for introducing electronic evidence? What was the learning from Arjun Pandit Rao's decision, which literally earnestly asked the legislatures to modify it, to relook 65A and B, and in no uncertain terms explained how UK, which is where we drew these two sections from, had already repealed both the civil and criminal provisions, the equivalence from which 65A and B came. So how much more direction did you need for you to know you have to drop them? Why did you not read 63 and 65 of the Evidence Act? I'm very sorry, I'm still quoting the old sections. But if you look at that for secondary evidence, it already captured mechanical reproductions. So why, and the one takeaway you all should note from Geeta's statement also is, what she was trying to say is, one, you have robust laws. Two, you have robust robust case laws, which have evolved from the laws. Three, therefore, when you're looking at changing something, should you just throw everything away or should we just add to it? And that's where I'm also coming in from. So when we had robust laws, we had case laws which had already evolved on secondary evidence and how to present it. If you really wanted to give ease of relying on electronic evidence, here was your opportunity to do away with 65A and B and bring in provisions which will ease the reliance on electronic evidence, which the Supreme Court repeatedly said was the best evidence you could rely on. Instead, you have this retained, I can tell you the provision 62 and 63 of the BNSS, if I may use the shorter form. Okay, let me try the law. BSA, Bharatiya Sakshya Adhiniyam. Pardon me for my pronunciation. Okay, or it could be Sakshya, I don't know. Anyway, BSA as I'd like to call it in shorter form. So if you're going to retain it, then you have to really rethink why are you retaining it and how really have you brought about a reform. So this is just one aspect in terms of evidence. Let me jump to jurisdiction. Harmonizing the 3 criminal major acts to ensure that the jurisdictional aspects that you have provided for, and particularly in terms of cross-border crimes, was critical. So if you have a provision which is the equivalent of IPC section 4, which had already expanded jurisdiction beyond the borders of India to say that it will capture offences from outside India, and it may also capture the commission of offences not just by citizens of India, not just by persons on a vessel registered in India, but also possibly by foreigners. And you also have under the old criminal procedure code a process for sanction, etc. Have you really reconciled the two? And if you have special provisions like in the Information Technology Act, which has also expanded the jurisdiction, then where is the harmonization? Again, the criminal reforms process was the way to sort this out. Unfortunately, one more miss that has happened. Are they all misses? Aren't there some hits? As I mentioned earlier, some of the additions are very critical, particularly in terms of some kinds of cyber crimes becoming part of it. And if you look at the organized crime provision, it's predominantly focusing on the financial frauds that have been rampant, more so after the COVID lockdown. Again, this is where I would like to pause to say, good, you brought something in, but bad that you decided to do the typical thing which is happening with drafting nowadays, which is cast the net wide. And let's see what kind of fish you get. That cannot be for criminal jurisprudence. It has to be specific. If somebody says, thou shalt not steal, you will know what not to do. If somebody is giving you a provision which is a paragraph in itself, then how exactly are you supposed to know what you're not supposed to do? Why couldn't they have made it separate provisions, right? So that's a matter of concern. If Macaulay's drafting lasted for 160 years, then it is a reflection on the kind of drafting. We are fully capable of doing that and more today. I wish that this additional effort had been taken. On the sedition aspect, I wouldn't say it's such a bad thing in terms of what is being retained. So I'm not evading the question. I was coming back to that. I always face everything head on, okay? The distinction that I see in terms of what we had and what we have is, the wording used was government of India. And unfortunately, people were misusing the word government instead of offences against the nation. So the one immediate reaction which I had to the new provision is that it moves from an offence against the government of India to offences against the nation. And it partially captures Article 19(2) and then expands it further. And the expansion is also not something we would not want in the interest of national security. To that extent, I believe it's fine. But ultimately, how a provision is being utilized. What is the leeway you're giving it for abuse? Where is it that you will draw the line? Could there have been further illustrations, etc., which would have explicitly clarified what is it that you can apply it for, what is it you cannot apply it for? These are all lessons we have learned time and again from abuse of a particular law. That these lessons have not been applied to this exercise is a given, and it's a very sadly a very big miss. And I really wish somebody had taken the time to relook it. But today we have to understand that it is already there at our doorstep. So for the youngsters, here is my advice and the closing comment on this. See, I already told you us old bandicoots are going to find it very difficult to relearn all those sections. You're going to learn it afresh. So here is your opportunity. That's a big hit, right? So here is your opportunity, take it. And the second part of it, what I would say is, I won't say bad news, but a little bit of a dark lining to the silver cloud is that you still have to learn IPC provisions. Because until such time comes when offences committed under the old act are exhausted. You know, so many years have passed that now everybody is only committing crimes under the new law. You still have to learn the old law, and you still should master practicing the same. Thank you.
Thank you, Ms. Nappinai.
And you will still need the precedents to get your client out. So you'll need the old section, anyone, after you learn the new section also.
Yes. Thank you, Ms. Nappinai. And I think that was, an overall on what we saw as to the shifting paradigm in the criminal jurisprudence with only misses. Moving to Shobhaji, before I, ask you your questions or request for your opening remarks, I want to place for the record of what has happened to the procedural code. The procedural code now has 531 sections. 177 sections have been changed. So bad luck for the old timers again. 9 new sections have been added. 35 new timelines, and that's where I would want your guidance, and 14 sections deleted. Shobhaji, you have been, I would say in a true sense, a legal warrior. Your journey, I think, is quite inspiring for all of us, what we have all seen. And you've stuck to a cause and fought for it, even as long as you saw injustice was being done. And we do see that in some form, the very same set of judges who we today don't find liberal did give the justice that you were seeking in the last part of what happened to the remission position. Your battle has been very long, and with this changing timeline that you see now coming with the CRPC, do you really think that this new changed timeline of everything being linked to 60 days, 90 days, 30 days, give reasons, finish it, electronic FIR, this entire new procedural code with electronic investigation, everything, do you think that what happened at the time when you were doing the cases originally and what was going on with those investigations, this is going to be a really beneficial legislation, particularly when it comes to offenses against women? And the other question that I have for you with regards to offenses against women, again an overhaul and a small addition, and coming from a man, I'm asking you
From a
this.
man, from a lawyer.
No, coming from a man, we've now been put down to a new nomenclature called false promise. So where do you see that false promise regime going? Because you've already seen, even in matrimonial cases, how 498A was being misused. Each of you have fought on both sides of the parties, and you have seen 498A being a provision not aptly used at larger occasions. With this new definition of false promise, a new provision of false promise, where do you see these offenses against women going as a result?
Kunal, I would dump your question when you ask as a man, okay? But we already had a session before, and we are not entering into this battle again. But yes, this is actually one welcoming change. Section 70 in BNS, I got to know, just as Nappinai was saying and Luthra ma'am was saying, difficult to remember the name and other things. Just as Nagaratna, when this Bilkis matter was going on and suddenly these changes came in, and she said, now you have come out with a new law and we have yet to remember, and it's difficult to remember the name even for people who are coming from South, especially from South. I realize it's difficult even for us. I come from a Hindi-speaking belt. Now, Sanhita, we have never read actually. Right? My juniors did a easy job. They call it, ma'am. So I asked them, when I got this thing and I have to do, normally what do? We pass on all the burden to the juniors. Acha, ye karo, and we get I have a ready mix here. So, so they said, so ma'am, we have to do a comparison between BNS and IPC. I said, what is this BNS? So that was Bharatiya Nyaya Sanhita. So it's easier. You need not to remember that Sanhita and etc. I am a teetotaler. I don't drink, so I would not enter into that arena of old wine and new bottle. Okay. But the fact remains, Kunal, I was just, they are experts in so many great fields, so I thought I'll work on that women area. I had confined myself to the crime against women aspect. What they have done, possibly they thought, okay, we'll assume the sections are ice cubes. Okay? The draftsmen in this regime, they thought, okay, let's put all the ice in one box, shake it well. Okay? And then pour it. And whatever comes in, start numbering it 1, 2, 3, 4. It looks like that. So it remains same. The heading of the section is same. The language is even, comma is same. No change. She is still at the wine stage. I was using ice for water. Or my milkshake. So, but one good change, two good changes rather. I understand somebody says, and I was, hearing one of the ministers, please forgive me when I'm referring politicians. So he said, see what we have done. We have brought the women issues in the forefront. 376, such a serious crime you would have in that chapter. We brought it in front. We made it something like 71, 72. This is the idea, bringing, the women issue in forefront. So that was, this is what apparently is the approach. This is how it has been explained. So all women-related sections have been brought at one place, possibly one change. Sections, name are same. Now you have to remember them, possibly put your memory lane again on a right split. We have had changes before in CRPC. So we kept reading, and it's an amazing exercise to do. Read that, keep these books, maintain these books. Later on they would be sold like gold. Because when the prints are out, now you don't get those earlier CRPC, okay? Save them. And I am rich one in that. We have many in our libraries. We'll save them. Compare the sections. And when these exercise of comparing sections, whether these are paramateria or not, the interpretation, as both the senior lawyers are saying, interpretation is something, an interesting aspect of it. Certainly we would be needing all these sections and the judgments because, as Nappinai was saying, you still have all those laws. Offenses are done, then they are registers, FIRs are registered. As we know in our country how good pace we work on with. So charge sheet would take some years, and then the offense in the lower court, then high court, then laying law down, things happen in Supreme Court would take years. For all these years, you would still need this section, these sections. And even for the new law to refer, you would need that. So that's there. Two good things which I was mentioning is section 228A, which was mostly missed, that don't reveal the identity of the women who suffered the crime, sexual crime. That has been brought here in one basket, if we say so. So one can easily, notice that and not miss it. Another important aspect is section 70, which Kunal, you were mentioning, false promise. We were seeing these cases many. You have live-in relationship, which has been now given approval by court. As a society, we have given an approval. So we have the instances where the promises of marriages are being made and then misses, like missing the promise. And here comes the allegation that that was a sexual relationship established on the promise of marriage, not fulfilled. We as a lawyers are finding it difficult, honestly, to fit it in the bracket of 376 somewhere and, getting the conviction done. Most of the time, if it is a promise and a consent relationship established, how are you getting into 376? So now section 70, that works well. That brings in this offense, which is a new offense introduced. But this we could have done without changing IPC to BNS. We could have just brought in one amendment. Like we have after Nirbhaya's case in 2013, so much of the amendments brought into IPC and CRPC and even to Evidence Act. Similarly, in 2018, after Kathua case, we had very, very welcoming amendments done. And we live by the amendments. Amendments are, the concept of amendment is made for this alone. That you bring in the amendments, fill the gap, bridge the gap, and live with the same sections. I personally do not understand, and I am on the same page, that does it serve any purpose? We never actually had a problem with IPC primarily. It defines the offenses and the penalties or the punishments. We have very huge windows for the punishments. And our courts are liberal enough to give very lesser one always, most of the time. We had a major problem with implementation of CRPC. CRPC again had no problem, no issue. Like it was a well-drafted law. Even Evidence Act, we had no issue. Greatly drafted. We failed seriously in implementation. I wish, like in Supreme Court, we have a procedure code. We name it something differently. Practice directions. Practice and procedure, I believe we have that. That lays down a guiding line for us or a guideline. How are we going to put in the procedures or the provisions in practice? I believe we needed something like that. A guideline principally for the police and then for the magistrates. That would have been done wonders. Timeline, as you were saying, Kunal, timelines are there. Believe you me, these timelines are going to really do the havoc in long run than to really help the purpose. We have to have our actions put in right place. For that purpose, maybe they have to have a training for the police persons. We've seen in a rape case in Jodhpur, a German lady was raped. The court had given conviction in 7 days. 7 days. This very country, those very IPC and CRPC and Evidence Act, the only thing is somebody who was implementing knew it, how to do it correctly. I wish the same way we are able to implement that now, but friends, live with it. The acts have actually been made applicable to be applied from July. So we have it now, unless somebody is actually repealing them. Thank you.
Thank you very much. As I think we've come to the close of the session, we've heard extremely bold comments from our panelists, extremely eye-opening. Personally, since Ms. Luthra has called me young, I beg to differ with all three of them to say why not change. We must have a change and we must learn to accept the change. We moved from physical briefs to iPads. We'll move from IPC to BNS, for sure. The concern that we go back home with is we amended our constitution in the last 74 years 106 times. We just don't see any confidence in our senior guiding practitioners to see the fate of this law not going through the same rigmarole that one of the most living, legendary laws of our country, the bedrock of our country, the Constitution, has gone through. The second concern that we go back home with is that all of this overhaul is too soon. Was our housekeeping ready? Why were the police reforms forgotten before bringing about this change? So, if our house is not ready, the implementation of that today is going to be very, very difficult. But I'm sure all three of them bless all of us as the younger generation to be able to try and see how we can bring about this change. All three of you have fought for justice, and maybe the younger generation will now fight for a reform in the police regime. Thank you very much, ladies.
Thank you so much, sir. I think you've summed it up perfectly. Let's just have a group photo and then Rishal will give us the mementos out for. Yeah. Can we please have a huge round of applause for all our speakers? That was a wonderful session. Thank you so much. That was really enlightening. You know, just as we say, justice delayed is justice denied. I guess justice hurried is justice buried. So, we'll take a minute and then we'll introduce the speakers later.